May it please the court? Mr. Ashton? Good afternoon, ladies and gentlemen. Good afternoon, Dr. Voss. Now, you are not a chemist.
Correct.
You're not an analytical chemist.
Correct.
You're not a biochemist.
Correct.
And therefore, you really can't testify as to the chemistry and the makeup of things of which you have no experience, correct?
Well, if I've never looked at something, yeah, I suppose that's true to a certain extent, yes.
Now, on your curriculum vitae, you put down that you got a bachelor's degree in biology,
Yes.
a master's degree in administration of justice,
Yes.
but you do not list what you got your PhD in. Could you tell the ladies and gentlemen of the jury what you got your PhD in?
Anthropology. Now, that was during the Fry hearings that was an omission that you pointed out to me that I recognized, and I sent an updated one to Mr. Ashton.
Okay. Now, the report that you issued in this case is labeled a forensic report, is it not?
Yes.
Okay. And on there, you have two co-authors, correct?
Correct.
Madavi Martin,
Dr. Martin, yes.
and she is a physicist.
Yes.
And you list that on your report, that she's a physicist.
Yes.
Mark Weiss,
Dr. Wise, yes.
and he is a analytical chemist.
Yes.
And you put that down, that he's an analytical chemist.
Yes.
And under your name, you put research scientist.
Yes.
You do not put anthropologist.
Correct.
Now, a majority of what you've testified to here today has to deal with chemistry, does it not?
Correct.
And of course, you would defer to Dr. Voss for anything having to do with chemistry.
I am Dr. Bass.
I'm sorry, Dr. Weiss, excuse me.
Well, we consult. I mean, yes.
Yes. And the reason you consult with him is because that's what he studied.
That's his expertise, yes.
And when was the last time you took a course in chemistry?
I guess probably doing my clinical pathologies
You have a year
degree,
for that?
probably in the 80s,
I'm sorry?
during the 1980s perhaps.
During the 1980s. Have you ever held yourself out as a chemist?
I'm sorry, sir.
Have you ever held yourself out as a chemist?
Held myself out. I mean,
Yes.
called myself a
Allowed
chemist?
people to think you were a chemist?
No, I don't think I ever have, no.
Have you ever read a Facebook account that lists you as a biochemist?
Relevance. Sustain.
Have you ever posted a Facebook account saying that you are a biochemist?
I never posted any Facebook accounts on anything.
How about Wikipedia explanation of your background? Have you ever put that you are a biochemist?
I have never submitted anything to Wikipedia on any topic.
Have you ever authorized anyone from the Oak Ridge Laboratories to hold you out as a chemist?
Not to my knowledge.
Are you aware that one has been posted that you are a biochemist?
Relevance. Sustain.
Now, you, sir, have a financial interest in your testimony here today, do you not, sir?
Not in my opinion.
Now, what you've done over the course of your career is you have studied human decomposition through buried remains, have you not?
That's one of the things, yes.
And the two papers of which you rely on your conclusions for this case comprised and built a database.
Correct.
And this database is what you use to render your opinions.
No, I would say that the peer-reviewed publications is what I used to render these opinions.
And that was part of what was comprised of the database, was it not?
Well, the database was used to present the data that was included in those peer-reviewed publications, yes.
How many chemical compounds have you, I guess through your research, developed that discuss, that comprise of this database?
I think I mentioned it was like 478, I believe, something like that.
What you ended up doing with this data, with the research that you did of 2004, was you buried 4 bodies.
Yes, that was the 2004 paper. Yes, sir.
And what you did was you set up all of the contraptions that you discussed during your direct testimony.
Yes.
And this allowed you to measure what comes out of the ground from the decomposing body.
It allowed us to measure what was generated at the body interface, what was moving up through the soil column, and what was being liberated at the surface of the soil.
And the very first reading that you got from those buried bodies was 17 days. If you'd like, I can.
No, I understand what you're saying. It took 17 days for the chemicals that are generated at the body to migrate up through the soil column to the surface.
Correct.
Yes, but I mean, chemicals are being generated at the body interface before that.
But it took 17 days to get up to the surface.
Correct.
Now, this database that you have comprised of, you have not turned over to the defense, have you, sir?
You may. Objection overruled. You may proceed.
Yes, sir. You refuse to turn this database over to the defense so we can have it independently tested and verified.
It's not mine to turn over.
It's apparently part of the grant that you were given to, is that correct?
It is a deliverable for the organization that paid for that research to be performed. That's correct.
And that has not been turned over to the defense.
I wouldn't know that.
Okay. You have no idea whether that was turned over or not, sir?
Well, I thought that it was turned over because I thought we had a depot just the other day on the database.
You're aware that we were given a list of the chemicals, but not the actual database, correct?
No, I thought you had been given the database.
Okay.
That's why we went to
Now, we have discussed that you've used this database and you turned it over to the people who gave you the grant for your studies, correct?
It was a deliverable. That is correct.
Now, part of what you do as a research scientist is you have to apply for and get grants.
Yes.
In fact, without the money, there's no research.
Correct.
And you work for a research lab.
Yes.
And that's different than a forensic lab, isn't that correct?
Yes, our product is research data.
And as part of your job, you have to bring in sufficient money to maintain your research, do you not?
Yes.
And part of what you are doing currently is you hold a patent for a device called the Labrador.
Incorrect.
Okay. You are an inventor of this Labrador? Partner?
I am listed as an inventor on a patent disclosure, yes.
Okay. And this Labrador utilizes this database.
It actually utilizes the compounds in the 2008 paper.
Yes. So that's a yes?
Partially. I mean, it does not use every compound in this database, no.
Okay. And what your goal is with this Labrador is to sell these units. They are handheld devices that look like a metal detector almost.
Correct.
And these devices, the goal is to sell these to police departments all across the country.
In my position at the National Lab, we are required to file invention disclosures. In this particular grant, which was separate from the development of the database for the chemicals, this was an actual grant from the National Institute of Justice, and it was designed to, the end product of that was an instrument used to aid and augment cadaver dogs to locate clandestine graves.
Did you understand my question, sir?
I'm getting to that.
Interrupting the witness.
Sustain. Finish answering the question, doctor.
And because of that project, a invention was developed. So we dutifully and correctly and filed an invention disclosure with the laboratory based on that instrument. Now it's the laboratory's decision whether or not to file a patent on that. I have no say whatsoever if the laboratory decides to file a patent or not. That is not my decision.
Did you understand my question, sir?
I think I answered your question.
I don't think you did. The goal of this,
Sustain.
the goal of this, sir, is to sell this to police departments all across the country.
No, my goal is not to sell these at all. My goal is to develop them so that an investor, if the patent ever gets awarded, could come in and license that patent, and they could build things. But the goal of the project was to create a technological tool that law enforcement can use to aid in locating clandestine graves.
And before that device can be built and processed and sold, you have to have validation of that database in a court of law, do you not, sir?
Objection. We approach.
Objection sustained.
I do not know that. Oh,
Objection sustained. Next question.
I didn't understand that.
You get royalties as a result if this device is sold and sold basically to police departments, do you not, sir?
I honestly don't understand the technology transfer process very well at the laboratory. I do understand that if a licensee comes in and licenses the patent, if it ever gets awarded, then there is a royalty fee associated with that, but it's relatively insignificant.
So the answer to my question is yes, you do get royalties if this is sold?
Objection. Counsel's rephrasing the answer.
Sustained as to asked and answered.
Well, it's insignificant depending on how many are sold, correct?
I'm sorry, sir?
The amount of money that you get, sir, depends on how many of these devices are sold.
I do not know if that's true. I think it depends on how much the licensee wants to pay pay for patent rights. That's my understanding. I'm not all that familiar with the technology transfer process.
It's also your understanding that you get 15% of the royalties, do you not,
Split
sir?
between the inventors. That is correct.
And part of the validation of this device would be to have it validated in a court of law.
Objection. Same question.
Sustained.
Now, when you billed out for the work you did in this case, you built it to the Labrador project, did you not?
Didn't know it.
You built it to the same funding source that gave you the Labrador funds, did you not?
The work I did in this case?
Yes.
No. This was done voluntarily on my own time.
And this Labrador, when you applied for this patent in 2006, did you not?
That was the first patent disclosure on a prototype that did not end up being the final product.
And that was done in 2006.
That was in 2006, the initial prototype.
And in your curriculum vitae, you have items that you had submitted patents for subsequent to that, correct?
Correct.
But you didn't disclose that.
Improper impeachment. We could approach, I could explain more.
I'm not impeaching.
You can
but-
approach. Objection sustained. You may
Dr.
continue.
Voss, when you publish an article on a specific topic, you're required as a scientist to give what is called a financial disclosure, are you not?
I don't think that's true.
You're required to explain what your if you have a financial interest or not in the outcome of the study.
I think that's true for certain journals, but I'm not sure it's true for all of them.
And when you filed your report in this case, did you disclose that you had any financial interest?
I'm sorry, is counsel asking about the report or the article?
He said a report. Doctor, do you understand the question?
No, sir.
Rephrase the question, Mr. Baez.
In your report in this case, did you disclose that you had a financial interest with the database?
My report to the detective and the investigator,
Correct.
no, I did not disclose it.
Okay. Now, the differences between, now I know we touched on this briefly, you work at a research lab, right?
Correct.
And the difference between a research lab and a forensic lab is a research lab does experiments.
Research data is our product.
Okay. And a research lab isn't required to have protocols.
Usually the research labs are the ones that develop the protocols and procedures.
So the answer is correct. Yes, right?
Asked and answered.
Wasn't sure if we got it.
Overruled. You can get clarification.
Can we get clarification? The answer is yes, you're not
Sometimes.
required to have protocols.
Sometimes. It depends on what you're doing.
For the work you did in this case, there are no protocols.
For this particular case, the protocols are published in the 2008 and 2004 peer-reviewed publication.
That's completely different than what you did in this case, though, isn't it, sir?
I do not think so.
The titles of your paper have to do with buried remains.
You're asking about procedure. We use Tedlar bags. We use cryofocusing. We use thermal desorption. We use GCMS. Those procedures were used both in this particular forensic report as well as in the peer-reviewed publications.
Let's see if we can keep it a little simpler. And let me ask you this. There is nothing in writing that tells you what procedure you must do when.
All you have to do is look at the materials and methods section of the peer-reviewed paper.
So there is something in writing that says, first step you do this, second step you do that, the next step you do this.
If you want to replicate an experiment, the procedures and protocols are listed in those publications, yes.
And the publications that you studied have to do with buried remains.
As I mentioned, the buried remains were part of the 2004 study. At the 2008 study, we started looking at surface individuals. We started looking at skeletal material as well.
Another thing that you don't have in research labs are quality control.
It depends on what you mean by quality control.
Quality control to ensure that there's no contamination.
Well, you run blanks, that's a quality control. You run blanks, you run standards. That's all part of quality control.
So it's your testimony that there is quality control that you utilized in this case.
Yes, we ran standards.
And is there anything in writing that you have that shows that proper steps were taken to avoid contamination in this case?
What type of contamination are you referring to?
We're dealing with chemicals, are we not?
Sure.
Volatile chemicals.
Yeah, yes.
And there could be a contamination issue if you have a certain item in a certain location that might be contaminated.
Are you saying the instrument's contaminated or the sample is contaminated?
Either one. Do you have anything in writing for this case of steps you took to prevent any type of contamination?
Well, I think in the bench notes that Dr. Wise wrote, I believe, he wrote down that, blanks one, the machine was calibrated, things of that nature.
We'll go into that in a moment. Anything other than Dr. Weiss's notes?
I don't recall anything, no.
Now, in this case, you did what was called a qualitative analysis versus, well, let me ask you that. You did what was called a qualitative analysis.
That is correct.
And what that means is basically you're identifying certain chemicals
That is correct.
as opposed to a quantitative analysis, which means it tells you how much of these chemicals is there.
Yes, qualitative can also include, hey, this is a big peak, or hey, this is a minute little peak. That can be qualitative as well.
As a scientist, you of course want to be precise,
You'd like to be, yes.
and especially in matters that you deal with, which are certainly very serious matters.
There are occasions where you want to be as precise as possible, yes.
So the research that you testified to in this case for this jury was a qualitative analysis, not a quantitative analysis.
Correct. We were looking to see plus or minus, are these compounds present, are they not present, and then give a rough idea of abundance, which means are they big, are they little, trace, things of that nature, yes.
Now, when you did your analysis in this case, you asked for, well, strike that. Let me go into another area that I'd like to discuss. First off, you issued a report in August as a preliminary report, did you not?
Yes, I typically do that.
And what that basically does is it tells you what you're looking at so far.
Correct.
It's certainly not your final conclusions by any standard.
Correct.
And you are aware, sir, that before you even had your conclusions in this case, it was reported to the media that you had found human decomposition in the trunk of this car.
Objection. Relevance.
Sustain.
Move to strike.
Judge, may we
Granted.
approach?
You can approach. You may proceed.
Thank you, Judge. Dr. Voss, you issued your first preliminary findings on August 26, 2008.
I can't confirm that date, but it probably is correct.
Okay. And shortly thereafter, within days, if not the same day, it became public, did it not?
I don't know.
Okay.
Apparently.
You were aware of the fact that this was released to the public, this information.
I think I was made aware, but I sure didn't do that.
I'm not saying you did, sir, but it was, correct?
If you say so, yeah.
Do you recall getting an email and having an email exchange with CSI investigator Vincent on the matter?
Well, I think I was upset because of all the media attention, if that's the email you're referring to, yes.
And this is because the media is already talking about your results before you even finish the experiment.
Relevance. Same objections. Court sustained.
Sustain, rephrase the question as we discussed it at the bench.
Yes, sir. It's your understanding that your conclusions were already being discussed without you even finishing your work.
I think that's correct, yes.
Okay. And that's quite a bit of pressure, is it not, sir?
I was not pleased with it.
That people know what you're going to say before you even say it?
Objection assumes facts that are not in evidence.
Sustain as
Move
to
to
that
strike.
question. Motion to strike granted.
Now, I'd like to start off, if you have your first preliminary report with you. Do you have that with you, sir?
No, I do not.
Okay. How many chemicals did you say you found from the carpet sample?
I don't have the report in front of me. I think 54 was the number at that point in time.
Correct. That's correct. Now, in your second report, how many chemicals did you list that you had?
I do not recall. I don't have it in front of me. I'm sorry.
Would it refresh your recollection if I showed you both reports? Is that a yes?
Yes.
Okay. May I approach the witness?
You may approach.
Okay. Yeah. Is that the second?
Could I look over the shoulders?
Sure, let me just find the. So in preliminary report number 1, you had 54 chemicals.
Yes.
And in preliminary report number 2, you reported 51 chemicals.
Correct.
But these were of the same run, were they not?
Yes, the reason for that is because evaluating those chemicals, we realized there was some overlap with gasoline. Not every compound has, a number of compounds have more than one name, like 2-propanone is also known as acetone, for instance. Methylbenzene is also called toluene. So as we went through those chemicals, if I recall correctly, we eliminated some of those duplications that were missed in the preliminary report.
What you had was, on report number 1, you found out of the 54, 43 were consistent with a decompositional event.
So we are.
Yes, sir. August 26, 2008. You found that there were 43 consistent with decompositional event, right?
Again, if they were duplicated, yes, that would make sense.
And when you found 51 in the second one, you found that 41 were consistent with a decompositional event.
Okay.
And then basically after that, you found on the first report, only 19 of these overlapped with gasoline constituents.
Okay.
And in your second report, you put 17 overlapped with gasoline constituents.
Okay.
Now, these all came up with you ended up coming up with the same exact percentage, did you not?
I do not recall.
Would it refresh your recollection if I showed you both reports?
It's possible, yes. But again, the conclusions of the final report were not based on these numbers, of course.
I realize that, but these are the chemicals. Even though it's the same exact run, you're giving different figures, are you not, sir?
Again, I have to literally go through every one of those chemicals and determine whether or not we had duplicate names, whether we used the gasoline components twice, things of that nature. I would consider the final report being the most accurate in terms of numbers like that.
Now, in your second report, you listed that you went to the junkyard and got 3 Pontiac Sunfires, did you not?
Correct. That was corrected to 2 in the final report.
Right. So let's see we're clear. What you wanted to do is you wanted to get these cars from the junkyard to compare them to this car.
Yes, we intentionally chose the worst possible urban-like contaminated area that we could as a comparison.
Now, you use these 2 cars as a real-world example of what I guess a standard trunk would be like.
Yes, we considered a new carpet to be an unfair comparison.
Now, in your report, you put 3 Pontiac Sunfires.
Yes, I think that initial error was because we took 2 samples out of 1 car, and I just mistakenly put down 3 instead of 2.
Then you made a correction and you did an affidavit. It's not really 3 cars, it's 2 cars.
That's correct.
As you're doing all these things, you take notes, do you not?
Sometimes I do, sometimes I do not.
And have you reviewed the bench notes in this case?
You mean the ones that Dr. Wise made in his analysis of the material?
Both the ones that Dr. Weiss and you made, sir.
I did not review his bench notes, no.
Did you look at how many cars were actually selected?
Objection. Counsel's attempting reference to Dr. Wise's notes. That would be hearsay.
Are you utilizing Dr. Wise's bench notes?
Sir, I believe this witness has testified as to the findings of Dr. Weiss.
Nope. Are you utilizing Dr. Wise's bench notes to impeach him?
Not to impeach him, sir, no.
Objection sustained.
Are you aware, sir, that there were actually 3 cars selected?
No,
Asked and answered, sir.
Overrule, I'll let him answer it one more time.
2 cars.
And you wouldn't happen to know the results of the 3rd sample, would you, sir?
Objection. Asked and answered assumes facts, not in evidence.
Sustained.
Now, you don't know the history of these cars that were at the junkyard.
Correct.
And you don't know the history of the car in Florida.
Correct.
So a lot of what you are testifying about is just a comparative analysis of what you found at the junkyard and what you got from Florida.
Correct.
And one of those cars, or one of the 2 cars that you testified about, had chloroform in the trunk.
Trace amounts, correct.
And what you did in that situation was also a qualitative analysis, not a quantitative analysis.
Correct. Qualitative, but we did take an area under the peak to get a rough idea of the difference.
Now, you've never done studies on what's in carpet.
No, have not.
In fact, you have absolutely no experience as to what the chemical breakdown is of carpet.
Correct.
And you talked about the odors of a rose in your direct testimony.
Oh, okay.
Is that a yes?
I didn't quite hear the question, I'm sorry.
My question was, you testified about the odor of a rose.
I used as an example, yes.
And you don't know the chemical breakdowns of what consists of what chemicals come from a rose.
No, it's just used as an example.
Or garbage.
Correct. I mean, it depends on what's in the garbage.
And in fact, there are a whole array of items that are involved in this case that you have absolutely no experience in as it relates to the chemical breakdown of these items.
Objection to the nature of the question without specifying the items. Whole array of items is very vague.
Sustain, rephrase the question.
Yes, sir. You were given a list of the items that were found in the trash, were you not, sir?
That is correct.
And in fact, you didn't actually see these items, you were just given a list of them?
Correct.
And you do not know the chemical breakdown of each individual item, do you, sir?
From what I don't have the list in front of me, I apologize, but what I recall is there were just empty plastic containers or perhaps an empty Coke can or Sprite bottle, something of that nature. I'm sorry, I just don't have the list in front of me.
But you can't testify as to what was in that garbage because you never witnessed it, did you, sir?
No, I did not.
And you don't know what the chemical breakdown of each of these items are.
No, but I can, but we did sample the air of the composite of all these.
And those samples were taken in August of 2008, were they not, sir?
I don't recall the actual date, but it's quite possible.
If I can have a moment, Judge, I'd like to.
You may.
August 30th of 2008 is, and I'm referring to State's Evidence 122, which you admitted into evidence. That was taken on August 30th, correct?
Okay. I would agree with that.
Okay. Would you like to see them, sir?
No, I trust you on that.
This was not taken on July 15th, 2008, was it? These samples.
No, you just said it wasn't.
And of course, you know that air is a free-flowing environment, do you not, sir?
Absolutely.
And that the chemical composition could change from moment to moment.
Absolutely.
But yet, you did your comparisons from air that was done a month and a half later, did you not?
Are we talking about garage air samples?
Yes.
Yes.
And you don't know what was done to that garbage between July 15th to August 30th.
I do not know that, no.
Now, what you did was you broke down a comparison and you did a table in your final report, did you not, sir?
Yes, it was very complicated, unfortunately.
And you used these samples to reach your conclusions, did you not?
That is correct.
And do you have that table in front of you, sir?
I do indeed.
Now, you used sample State's Exhibit 117, State's Evidence 117, which is the air sample from the trash found inside the vehicle. That's on your table.
If you're referring to column 3, that is correct, in that table.
Could counsel designate for the benefit of counsel which table he's talking about in the report?
Table 1.
Thank you.
You used State's Exhibit 116, I'm sorry, State's Evidence 116, which is the air sample from the passenger area of the car.
All right, hold on just 1 second.
I believe that would be the one that says Florida vehicle interior.
That's the 4th column.
Yes.
Correct, yes.
So use this one too.
Could I look at counsel? I'm having trouble finding what counsel's referring to. Oh, this is the
Yeah,
table
yeah, that's the-
appended to the report. Thank you.
State's Exhibit 115, which is also an air sample from the passenger area of the car.
Okay.
State's Evidence 122, which is air samples from the garage of the forensics bay.
Okay.
You considered State's Evidence 121, which is I guess this is a trip blank.
Yes, I did trip blank.
State's Evidence 120, which is an air sample from the garage. State's Evidence 119, which is an air sample from inside the trash.
Okay.
But you did not, sir, use State's Evidence 118, which is the air sample from the trunk of the car on your table.
I did not. In my table, no.
Yes.
But I
fact-
did mention it in the report.
It's not what you used to reach your conclusions, did it, sir?
No, because the complete liner had been removed, and we were simply looking at what was present when, what was present after everything had been removed. It was not a valid comparison.
But you were willing to use air from everywhere else except the trunk of that car to include it on your table for your opinions.
Okay, but you have to understand that when you collect a triple sorbent trap, and in this case, Investigator Vincent collected about an hour's worth. That converts to approximately 30 to 40 liters of air that were collected and concentrated on the triple sorbent trap. That was compared to 10 mils of air off the trunk liner. If you look at the table, I know it's complicated, but it indicates that without doubt, the point source of the odor was the trunk. Now, we did do an analysis using a TST of the trunk, indicating that trace amounts or small amounts of sulfur compounds and chloroform were still detectable in the trunk, even though the liner had been completely removed. I do not consider that a valid comparison.
You don't consider the air in the trunk of the car valid?
Not
Because
after
the
the
liner
liner had
was
been
removed.
removed. I didn't say it's not valid, it's just not a valid comparison.
Now, Dr. Voss, let's break this down a little bit further for us. Out of the 17, you were found 7 to be relevant to your 30 main compounds.
With the aforementioned caveats, yes.
And because of some overlap, or because of trace levels, you only considered 5.
That is true. We were very, very conservative.
And out of those 5, there was overlap with 2 of them, were there not?
I'm not sure I understand that what that means.
Out of the 5 chemicals, there was overlap with some of the other chemicals found in your table that could be accounted for something else, and it only broke down to 3.
Well, again, I mean, in most cases, what we call is that they're in trace amounts.
But there are 3, correct, that did not overlap out of your list of 30.
I'm not quite sure I would completely agree with what you're saying. You have to look at the chemical composition of each particular sample. And as I mentioned before, it can be occasionally compounds present that overlap with other things. So I wouldn't simply eliminate a compound because it's in minute trace amounts, especially if it was found after you collected 30 liters of air compared to 10 mils of air.
But there is overlap from other items.
Well, with the caveats I just mentioned, yes, there's a little overlap.
And the only thing that does not have overlap are 3 chemicals.
Again, with the caveats I mentioned.
Okay. So 3 chemicals out of the 30 that you consider significant in human decomposition.
I think that's an unfair statement because we're talking about quantities of material. I mean, there's a process called diffusion where things go from high concentration to low concentration. If the trash was in the car and the trunk liner was emanating high concentrations, it's very possible that a small amount of material adhered to some of the trash. And when we collected 30-odd liters of that and detected a trace amount, we detected that and undutifully reported it on this report. So I don't think that is an accurate depiction of what we actually came to the conclusion with.
And you would rather go with the 5?
Actually, I go with about 8, to be perfectly honest with you. But in my conclusions, we did describe 5, yes.
In your 2008 paper, you gave a table of 30 chemicals that are significant in human decomposition.
Again, with the caveats that some are aerobic, some are anaerobic, some in early decomposition, some in late decomposition.
So that's correct, right?
That's correct.
This list of 30?
Yes.
Okay, and that's representative of this.
Correct.
And out of what we've got here, excluding overlap, because you can't account for it, can you?
Again,
You don't know the history of these
Objection.
cars.
May the witness be allowed to answer the question?
Yes, sir, did you finish answering the question?
I can't recall. I'm sorry.
I'll read back our questions so the witness can answer it, please.
I'll withdraw the question.
Your Honor, I would ask the court reporter to read back the questions the witness started to answer so that he can finish his answer.
Madam Court Reporter, please read back the last question.
Would be the one that precedes the well on the list.
And out of what we've got here, excluding overlap, because you can't account for it, can you?
You cannot account for it, but you can make an assumption based on properties of diffusion as well as the quantities of air that have been compared.
And assumptions aren't exactly scientific, are they, Dr. Voss?
Sometimes they are relevant in a conclusion.
Assumptions are sometimes relevant in conclusions?
Sure. Common sense included in that.
This 30 constitutes the main breakdowns from the 478, isn't that correct?
What we consider the significant ones, yes.
Okay. Now I'd like to talk about the second area that you testified, which was the LIBS, the laser-induced breakdown spectroscopy. You are not a physicist.
Correct.
And the compounds that come up with this, can you identify those 4 compounds again that were found?
In the LIBS analysis?
Yes, in the LIBS analysis.
Can I confirm my report?
Yes,
Can I just be
yes,
sure?
absolutely.
It was calcium, magnesium, sodium, carbon, and iron.
And these items are found in numerous items in the environment, are they not, sir?
Absolutely.
And they are also found in common trash, are they not?
I don't know that.
Okay. And that's because you're not a physicist.
No, it's because I haven't done it. Inorganic analysis of common trash.
And you're not a chemist, correct?
Okay, I'm not a chemist yet.
Yeah. You made a comparison for this jury saying that this car from the junkyard, the levels of these items are much lower than the ones in Florida.
Correct.
Okay. But you don't know how long that car was in the junkyard.
Absolutely do not know.
Could have been there years
Could have been.
Soaking up all of the natural environments.
You mean the junkyard car?
Yeah.
Yeah, isn't that cool that they were less than what was in the Florida car?
Could have gone through winter.
Absolutely.
Snows up in Tennessee, does it?
Hmm?
Is that a yes?
Yes, I'm sorry, yes.
Could have gone through summers,
Summers?
and you don't know how many.
No, sir.
And you compared that, only 2 cars, to this car in Florida, for which you also have no idea the history in that car.
Correct. We considered that the worst case scenario that in a urban environment, in a junkyard, you would have oils and greases and cleaning products perhaps, and maybe blood from car wrecks, all these things that potentially could have contaminated the trunks of these cars. That is correct.
But you didn't even collect those samples, did you, sir?
The junkyard samples?
Yes.
I did not collect those, no.
So you don't know if these are trunks that have the trunk lid missing?
Oh, in most cases in this junkyard, the trunk lid was not missing, but open. Because obviously people want to come and take pieces off of cars in a junkyard, so you don't want to have anything locked up.
Is that an assumption, sir, or is that a fact?
That's what I was told from the person who collected this.
You were told that these were with the trunk open.
Unlocked. And I believe open, yes.
And you compared that to a car that had trash in the trunk for 3 weeks in the hot Florida sun.
Objection, simple fact, which is not in evidence.
Sustained. This would be a good time to take our afternoon recess. We'll take a recess to 10 minutes past the hour of 3.
All rise for the jury.
Okay, state recognized persons of the jury
Yes, sir.
and the defense.
Yes, sir, we do.
Okay, you may continue.
Dr. Voss, before I go further into the lid, while we were talking about the carpet samples, it came to your attention that the entire trunk was sprayed with a chemical called Blue Star, did it not?
Yes.
And Blue Star is an item similar to luminol,
I believe so, yes.
and it's used to detect blood with an alternating light source.
I believe so, yes.
And you had requested that you do a control by spraying the carpet with Blue Star, did you not?
I don't recall doing that, no.
If I could have just a moment, Judge.
You may.
The spraying of a carpet sample with Blue Star was never done.
Well, it was in the trunk of the car, apparently.
My question to you, sir, is the spraying and running a sample to see the effects of Blue Star as to these chemicals was never done.
I did not do that, no.
Okay. Instead, somebody went to a website and printed out the ingredients.
The material safety data sheets.
Yes. And that's all that was done. There was nothing further to see how that would have influenced your findings.
No, when a chemist looked at that MSDS sheet and said the chemicals present could not have contributed to the chemicals that we found relevant, I didn't pursue it any further.
Nothing further was done.
Not by me, no.
And you're aware that the entire trunk was also sprayed with Febreze, were you not?
Yes.
Okay. And you did no studies to see how those chemicals interacted with your findings?
No, but we did look up an MSDS sheet of Febreze, and that's essentially fragrances and a little bit of ethanol.
And you don't know what effects those chemicals would have with the chemicals that were already found in the trunk of the car, do you, sir?
You mean interactions between it?
Correct.
I do not, but I don't envision any, no.
Okay. And again, you are not a chemist, so these are things that are a little bit outside of your area.
Okay.
Is that a yes?
Yes.
Okay. Now, while we're looking for that, I'd like to talk to you about the lids again. With the court's permission, I'd like to have you write down the findings of the chemicals that were found in the litters. May the witness stand out here?
Would object.
He's already expressed them twice. Counsel can write them.
I can write them down, that's fine.
Okay.
Counselor?
Yes. I'm going to refer my report one more time.
What's your spellings? Let me know.
Calcium, yes, and sodium.
What else?
Sodium,
I'm sorry?
Sodium.
magnesium. Close enough. Iron. And carbon.
Carbon. Dr. Voss, how many of these chemicals would you get if you picked up a piece of soil from the ground and tested it in a GCMS?
I'm sure small amounts of every one of those might be present.
And again, what was done was a qualitative analysis, not a quantitative analysis.
Correct.
Now, I'd like to shift focus to the paper towels. These had different, what you called fatty acids.
Correct.
And sir, these fatty acids included palmitic acid,
Correct.
as well as stearic acid,
Yes.
oleic,
Oleic. Good try.
and myristic.
Myristic, yes.
Myristic.
And palmitoleic.
What's the other one, I'm sorry?
Palmitoleic. Let me look at my report if I can.
Sure.
Do you know what page it was on? Let's see, hold on.
Would be on your final report, page 7.
Oh, page 7.
Second paragraph under paper towels. I don't see that one there.
Oh, yeah, 1, 2, 3, 4 sentences up from the bottom in that paragraph. Near the end, palmitoleic. Fourth up from, the one that starts with fatty acids. The third paragraph in that section.
Third.
Fourth sentence up from the bottom near the end.
I see.
You got it?
Okay, I see. I'm sorry. Now, sir, you mentioned in your report that these are fatty acids that are like adipocere.
Yes.
Okay. You don't say adipocere. You say like adipocere.
Okay, just semantics.
Okay. Now, you of course know that adipocere is normally found in wet, marshy conditions.
If fats are present, wet conditions are one factor that can contribute to its formation.
And of course, you know that it takes weeks to months to develop adipocere, do you not, sir?
It takes weeks to months to develop morphological appearance of adipocere. It takes just a few days for the lipases to break down the fat.
And I'm sorry, go ahead. I didn't mean to interrupt you.
What's interesting about adipose tissue, it's made up of triglycerides. Tri, of course, 3. So 3 fatty acids are hooked to glycerol. And the fatty acids could be any one of those, of course. And it depends on the number of carbons in that chain. Stearic, for instance, has 18 carbons in it. Myristic has 14 carbons in it. Palmitic has 16 carbons in it. The unsaturated, which means there's a double bond, include the palmitoleic and oleic acids. And so lipases, those are enzymes that break down lipids, then release these particular fatty acids in adipose tissue.
These were found on a paper towel that was found in the trash. Correct?
I believe that's correct. Yeah, I believe it's in the trash, yes.
And you could find also these items in a hamburger.
I don't know if that's true. First of all, the hamburger would have to be completely raw. You'd have to have a huge percentage of fat in it.
You could also find this in chicken.
I do not know if that's true or not.
Okay. And is that because you are, again, not a chemist?
No, I haven't looked at the fat on a chicken before.
Okay. And you've never studied that. You don't know what other logical explanations there could be to find these on a paper towel, do you, sir?
I'm sorry, I didn't understand the question.
You have never studied whether you could find this in chicken or hamburgers or any other meat products because, of course, you've never studied that.
The formation of adipocere is favored by several.
Now, I'm not talking about adipose here, sir.
The witness.
Stein, finish answering the question, Doctor.
The formation of adipocere is favored by a number of issues. One is an anaerobic environment. One is an alkaline pH environment. One is a temperature between 22 and 40 degrees Celsius. And one is a dry to saturated moisture level area. So those things really need to be in conjunction for adipocere to form.
Sir, I wasn't asking you about adipocere. I asked you if these chemicals, can you find them also in meat products?
I do not know the answer to that.
And that's because, of course, that's not an area of your expertise.
Well, I believe, personally, I would think that yes, in mammals, that would be true.
Okay. Now, there's another item or chemical that you found on these paper towels that you did not testify to the jury during your direct examination. Do you recall what those are?
No.
Do you recall finding small amounts of THC and cannabinol?
Oh, yes, okay.
What is that, sir?
Those are just byproducts of marijuana, metabolites of marijuana.
So you found products that could be found in meat and also products that could be found in marijuana on these paper towels.
Correct.
Now, is it still your testimony that this could be adipocere or could it be someone with the munchies?
Again, in order for these products to form under the definition of adipocere, the meat would have to be raw. You'd have to have loaded with bacteria like Clostridium, because that bacteria would produce the enzymes that would break the triglycerides down. You'd have to have an anaerobic condition, so if you were eating a piece of hamburger, it'd have to be raw and with a bag over your head, and you'd have to have a significant volume of material to create a stain like what we noticed in the trunk of the car. So we're talking several pounds of meat, if that was.
Do you know if people use paper towels to clean up raw meat when cooking?
Yeah, I have. How can I possibly testify to that?
Oh, okay. Now, how did the marijuana get there? Is that a byproduct of decomposition as well? Marijuana?
No. It was just we tried to be as thorough in our reporting as possible.
Now, you mentioned that you have protocols when utilizing this database. And these protocols, the only times that you've used this database are in 2 cases, correct?
I think you'll have to clarify before I can answer that.
Do you recall attempting to find hidden graves at the Barker Ranch in California?
Relevance may we approach?
You may. Okay, members of the jury, there's going to be a brief matter we need to take up outside of your presence. I will get back with you as soon as I can. Okay, Mr. Baez, you may proceed with your proffer.
Yes, sir. Dr. Voss, in 2008, March of 2008, you were asked to analyze some soil samples for the Barker Ranch. Is that correct?
Yes.
And what happened was you were sent these soil samples
Correct.
and they were analyzed using a gas chromatograph mass spectrometer.
Yes.
And what your initial findings were that they were consistent with a decompositional event.
Yes.
And subsequent to that, you went back and you actually went on a trip to the actual site.
Correct.
At that location, you used several instruments in the locations that were identified by cadaver dogs.
That's true, yes.
And including the GCMS, you also used a magnetometer.
I personally did not, but a magnetometer and a ground-penetrating radar device was utilized, yes.
That, in conjunction with your findings, an excavation ensued.
A exploratory excavation ensued. That is correct.
And you dug and did not find any bodies at the location that you dug.
At the depth we dug, we did not find anything, but the caveat there is at the depth we dug, we just got to the surface of the original ground from 40 years ago. These bodies were 40, 50 years buried. So there's been a lot of flash flooding, there's been a lot of movement of earth, and the depth we dug, we just got to the surface of that particular site, if you will.
And subsequent to that dig, it was your conclusion that this science is at its infancy stage, is it not? Was that not your statement?
My statement was that we didn't understand the environmental parameters well enough. I think the chemistry is well established.
But your statement, sir, was that this science was at its infancy stage.
Objection. Counsel state that time, place, and person is present in this prior statement.
Did
Mr. Baez?
Did you make that statement, sir?
Objection. We need to know time, place, and person is present.
Rephrase your question.
Yes. Did you make that statement, sir, to a member of the media while granting an interview that the science of which you employed was at its infancy stage?
Same objection.
Sustain. Unless you put the proper parameters, date, time, and place.
The only time that you have used this specific science with the database to actually find a body was the Barker Ranch, correct?
No.
And when you were not successful, what are your error rates for coming up with bodies after a analysis is done on the GCMS?
You can't use error rates for such a determination. Error rates are a measurement of an error associated with a measurement, like taking a ruler, is it really 2 inches or 2.1 inches or 1.9 inch? That does not apply because in the 2007-2008 timeframe, as I previously explained earlier, we did not fully understand environmental parameters associated with this type of a search. So we're talking about high barometric pressure. You know, if we did a search during that time period, we wouldn't have seen any chemicals in the surface.
I have no further questions, Judge, as to the problem.
State?
Question, sir. Did you, sir, on May 22nd, 2008, give a statement to the Associated Press that we're trying to improve the science, it's in its infancy. There could be additional people out there, but unless there are leaps in this kind of science, we'll never know.
I cannot verify I said that. I mean, I don't know what the initial question from the reporter may have been. It may be taken out of context. I do not know. I could be referring to environmental conditions. I can't verify that.
Did you make the statement, I haven't been this frustrated in a very long time?
It sounds like something I'd say. Digging holes is not fun.
Okay, I have no further questions.
You want your stuff back, Mr. Bias? I thought you said you were done.
For his proper. You have any cross-examination for the proper?
Yeah, I do.
Proper, I'm sorry.
The limitation in the depth that you were permitted to dig why was that limitation placed on you?
Primarily time constraints, as well. It was just simply an exploratory dig. It was not a full excavation, just to see essentially what we could find. I mean, you know, are there any indications that a burial situation had occurred at those locations?
Would it be fair to say that at this point, nobody knows if there's actually a body down there or not?
That is a fair statement.
So the record to be abundantly clear, the Barker Ranch is a ranch where Charles Manson murdered and buried some people. Is that not correct, Doctor?
That is correct, sir.
These murders, if you can recall, occurred when?
40, 50 years ago. It really has no bearing on this particular case at all.
Okay. Anything else, folks?
Nothing further.
Okay. The questions dealing with the Barker Ranch will be, objection will be sustained. As I indicated, if you want to talk to him about cross-contamination with garbage in the trunk of the car versus the alleged odor of decompensation, you can. But the Barker Ranch and what was done there has no bearing on this particular case. It's irrelevant and immaterial. The conditions are totally different.
Yes, sir.
Environmental conditions, unless it can be shown that they have some bearing or relationship to this particular case. Okay, anything else? Anybody need to take a break before we return this jury?
Jane? I guess he's all right. We're good.
All right. Let's return to jury. Okay, you may proceed.
Thank you, Your Honor. Dr. Voss, we're going to switch away from the fatty acids and marijuana, and I'd like to ask you a little bit about protocols. Now, part of protocols would also include specific instructions for the proper collection of these samples, correct?
Could, yes.
And in fact, you have had protocols when collecting samples that would advise people or those collecting the samples to avoid storing the sample vials in an area that's contaminated with organic vapors such as gasoline.
Depending on the circumstances, that's of course true.
So as part of your protocols, you have told individuals not to collect or not to try and contaminate these samples with areas that are near gasoline.
Well, that's common sense, yes.
And you're aware that in this case, the samples were collected in an area that contained gasoline.
Well, yes. I mean, that's where the evidence was.
Now, part of another part of your protocols is to collect that the collection samples should be free of trash, debris, and obvious sources of chemicals that could result in false positive readings. Examples of trash or debris that would create false readings are...
Objection, counsel, reading a document that's not in evidence.
I'm asking him a question, Judge.
He's still reading a document that's not in evidence.
Overrule at this point.
Examples of trash or debris that could create false readings include aerosol cans, gas cans, propane bottles, or any other man-made container or trash that might emit volatile organic compounds or be responsible for releasing organic compounds into the soil. Even a spilled soft drink can introduce flavorings and other chemicals into the soil that could produce false readings.
What was the question?
Those are your protocols that you have given
Yes,
in
I mean,
collection of these types of samples.
yes, but you can't take it out of context. From what I recall, we wrote those protocols in response to an investigator who wanted to collect environmental samples in a very large area, an open field type of an area. Obviously, you don't want to collect a control sample where there's a pile of trash in a 40-acre field. That just wouldn't make a lot of sense. So you have to take that statement into context.
You don't want samples collected near trash because it could create false positive readings. Is that correct?
Unless the trash is part of a crime scene.
You don't make that distinction, though, in your protocols, do you, sir?
Well, again, we were talking, if I remember correctly, we were talking about collecting outdoor soil samples in a very large area, and the question came up, where should I collect a control sample? And these are conditions that made, common sense.
Because you don't want them collecting these samples near any gasoline or trash.
Well, it just wouldn't make sense if you're in a 40-acre field.
Especially because they could create false readings. And that's true, sir.
Sure. I mean, as long as it's not part of a particular crime scene, which is part what you need to collect as evidence.
And I'd like to talk to you about another topic, sir. Can you tell the ladies and gentlemen of the jury what divining rods are?
Objection, relevance.
You may. You may proceed.
Thank you, Your Honor. Dr. Voss, you had testified under direct examination about your ability to find clandestine graves.
Your Honor, is counsel withdrawing the first question that I get?
Just putting it into context, Judge.
I don't think so.
Do you know what divining rods are, sir?
Yes.
And could you tell the ladies and gentlemen of the jury what divining rods are?
Divining rods are antenna used to locate specific properties of specific materials.
And can a divining rod be made of a coat hanger from a dry cleaner?
Sure, as long as it's the right material, yes.
And have you taught on this subject to use coat hangers to find hidden graves?
Absolutely, it's a hobby of mine, just like stamp collecting, coin collecting, and it teaches wonderful scientific principles.
And sir, were you offered $1 million to prove this theory of yours?
Sustain as to that question.
Have you been challenged in any way as to the credibility of this theory of yours?
Sustain. Let's move on.
Sir.
Mr. Baez, get to the points I said you could
Yes, sir.
get to.
Now, you also have attempted to put electronic leashes on flies, have you not, sir?
Sustain.
Move to strike.
Granted.
Sir, the testimony that you've given here today is the first time that you have given this type of testimony in a court of law. Isn't that correct?
Yes.
In fact, it has never been admitted in any court across the country. Is that correct?
Objection. Relevance. Move to strike.
Overruled.
Is that correct, sir?
I wouldn't know that.
You have no idea, sir, that this is the first time your database has been admitted in a court of law.
Well, I don't know if anybody else has another database, perhaps. I don't know that.
Now, you know that your findings are not generally accepted in the scientific community, do you not?
Objection.
Sustain.
To strike.
Granted.
Are there any other papers or studies that have the same findings as you do, sir?
There is a paper by Dr. Stathopoulos who looked at whole bodies, and of the 5 primary chemicals that we used to make a conclusion in this case, he also identified 4 of those in his study. He did not find chloroform.
Okay. And Mr. Stapolopoulos is, Strathanopoulos?
Stathopoulos, I believe.
Staphopoulos. Mr. Staphol, the gentleman you referred to, he is located in Greece.
Correct.
And in the entire world, the only person that you think agrees with your findings is this gentleman in Greece.
Objection. Relevance of the question. Who agrees?
Sustain.
I'll rephrase it, Judge. The only other study that you find are similar to your findings is a gentleman in Greece whose name I can't pronounce.
I think he's the only one that actually used entire bodies. I mean, there are a number of people that use pieces of tissue, but I wouldn't consider that comparable.
And he has a completely different database other than your 478.
Absolutely. He was looking at a single time point. We were looking at a 5-year study, a 4 to 5 year study.
If I can have just one moment. Testified under direct examination that the smell of human decomposition is unique.
To me, it is, yes.
This is the portion where Mr. Ashton wanted to step away from the science. Do you recall that question?
Not exactly, but
Okay. He asked you what your opinion was, and you said the smell of human decomposition is unique.
yes.
Do you recall making a statement, sir, to the Knoxville News on December 14th, 2008, that the smell of human decomposition smells like a potato gone bad. That it is sickly sweet, it doesn't smell like a swamp or a rotten egg smell. If you ever had a potato go bad in your cupboard, that's a horrendous smell. That's very similar to human decomposition. It's amazingly similar.
I believe I made that statement, yes.
So it's specifically unique to a potato.
Yeah, but we actually looked at a decomposing potato, and the chemical composition is completely different.
If I can have just one moment, Judge. Now, sir, one of the key markers of decomposition, of human decomposition that you have found is that fluoride is one of those chemical signatures, is it not?
A halogenated fluoride compounds are, yes.
And in this case, you did not find any fluoride.
That is correct. Neither did we in the positive control.
And the positive control that you got, that you've based this entire finding on,
Objection, counsel's statement, basing the entire finding on facts, not evidence.
Sustain, rephrase the question.
yes, sir. The positive control, so we could let the ladies and gentlemen of the jury know, is you got a blanket from a body that was of a child in the trunk of a car for 3 months.
That is correct.
Okay. But you don't know the circumstances surrounding when it was recovered,
Correct.
how it was stored,
Correct.
or any of the circumstances surrounding the death of that specific homicide.
That is correct. But nevertheless, we saw the 3 primary sulfur compounds, and the point of that control was to verify that compounds such as the ones we found in the Florida trunk could be formed in the trunk of a car.
And of the 30 key markers, the 3 ones are the main ones that you found to be relevant in this case.
Again, I think you're twisting things around a tad. I mean, again, we're looking at 30 compounds. If you eliminate the gasoline overlaps, if you eliminate the fluoride compounds, which, again, were not seen in the positive control, and I have an opinion of why that may be, and then if you eliminate those compounds that are only seen late in decomposition, that leaves 10 compounds out of 30 that we considered relevant. And of those 10, 8 were found in the trunk of the car. That's about 80%.
But this entire experiment that you conducted in this case is completely from items of which you have not collected, correct?
Well, I didn't collect the trunk carpet sample. That is correct.
Or the air samples,
Correct.
or the blanket sample,
Correct.
or the samples at the junkyard.
Correct.
And not only did you not collect any of these items, you have no idea of their history or makeup.
Well, we did a chemical analysis. I know the makeup.
The history and the makeup of those specific items.
Well, I don't know the history. No.
You have no idea what chemicals they may have encountered.
Objection to the compound question of they, not specified.
Sustain, rephrase the question.
You have no idea what was in the trunk of this car for the Pontiac Sunfire in the 10 years that it was in existence, correct?
Are you referring to the Florida or the junkyard?
The Florida Pontiac Sunfire.
No, I do not.
And you don't have any idea of what the chemical makeup was of any of the junkyard samples that you collected.
No, we analyzed the junkyard samples and we know what gases are liberated. Is that your question?
You don't know the history of those cars.
That's correct. I do not. I've stated that.
And you also don't know the history of the car from the Montana sample.
That is correct. I do not.
And you never even collected a carpet sample from that car.
No, the child in that case was wrapped in a blanket. The blanket is what was stained. And again, granted, it's not a perfect positive control. I mean, thank goodness I don't find all these children in trunks.
Objection, Judge. I'm going to move to strike that answer.
Overruled.
Sir, you don't know the history of that sample.
Correct.
And you also never collected a carpet sample from that car.
No.
And this is the very first time you have ever conducted an experiment on a carpet sample.
That's the wonderful thing about forensic science is every sample is unique.
So is the answer yes, this is the first time?
That is correct.
If I can have just one moment, Judge. Sir, you're not a member of the American Academy of Forensic Sciences, are you, sir?
Objection, relevance.
Overruled.
You're not? Yes, sir.
No, not currently.
And in fact, you're not a member of the, is it the American Board of Anthropology?
Objection, relevance.
Overruled.
No.
And you are not a member of any professional organizations that would govern its members, are you, sir?
No, and my background is so diverse, I wouldn't even know which one to possibly join.
Because, of course, your ideas are so unique.
I'm being paid to be creative and think outside the box. I don't even know what the box is.
And you would, of course, consider yourself more of an explorer than a scientist, wouldn't you, sir?
Objection, relevance.
Sustained.
I have no further questions at this time.
Redirect.
Which would you say has governed your professional career more? Scientific curiosity or financial benefit?
Overruled.
Obviously, scientific curiosity. I'm a very curious person.
Though you indicated you are not an analytical chemist, the past 20 years of your career in forensic anthropology, has that centered around the biochemistry and the chemistry of decomposition?
Yes.
Do you feel you have a financial interest in this case?
Not at all.
When you were asked, you remember when your deposition was taken in this case by Mr. Baez?
The Inquisition, you mean?
Deposition.
Yeah.
That was back. Back on September 22nd, 2010.
Yes.
You remember you were asked questions about this, the patent issues and the royalty issues and all of those things?
Yes, unfortunately, yes.
Yeah. Did you have to refer to someone else to get the answers to those things?
Absolutely, yes. I had no clue of the actual procedures that I needed at that point in time, no.
So you didn't even know how it worked or what royalties may or may not come? You had no idea at the time of that deposition?
Well, one, it never interested me.
Okay. But after the deposition, did you have to go and ask people to educate you on that so you could answer these questions here today about it?
Yes, I did, actually.
In seeking out a control sample of carpet, did you deliberately try to find the most contaminated carpet you could?
Yes.
And that's why you went to a junkyard?
Sustained, rephrase the question.
Was getting a contaminated sample part of the reason you went to a junkyard?
Yeah, I'm sorry, I missed the beginning.
Was getting a contaminated sample part of the reason you asked them to go to a junkyard?
Absolutely.
Now, you talked a little bit about diffusion, and I want you to explain to the jury what you mean about odor diffusion.
Diffusion is a process where chemicals go from higher concentrations to lower concentrations. If you have a piece of plastic over here that has part per trillion levels of compound X, and you have a piece of plastic over here that has a compound X in it, but at parts per million levels, this sample could never contaminate that one with that compound because it diffuses from higher concentration to lower concentration.
And is that the significance of finding the point source of the odor?
Absolutely.
And in this case, what was the item that had the highest concentration of all of these important chemicals we've discussed?
That carpet, spare tire carpet cover sample.
Now, you were asked about two products that may have been sprayed in this trunk. One was Blue Star, the other was Febreze. Did you look up the material safety data sheets on both of those products?
No, I think the MSDS for the Blue Star was sent to me by Michael Vincent.
All right.
And I actually did look up the Febreze one myself, yes.
And is the MDS a source of information that is normally relied upon by people in your field to get the information about the chemical composition of, household or manufactured products?
Well, actually, before we use any chemical in a national laboratory, we actually must consult a material safety data sheet to look at possible interactions with other chemicals, hazards associated with it, safety precautions, things of that nature.
Did either of those chemicals, either Blue Star or Febreze, contain chloroform?
No.
Now, you were talking about the paper towels and the volatile fatty acids that were found in the paper towels. You indicated that it was possible that that could have come from meat. Give us a scenario that could have, using meat, that would have caused what you found in those paper towels.
That's not going to be easy. The meat, again, will have to be raw. It'll have to be uncooked. It'd have to have a high percentage of fat associated with it. It could not be from like butter fat or milk. It'd have to be from like a mammal of some sort. It'd have to be of sufficient size to create the stain that was found in the trunk of the car.
Judge testifying outside the scope and...
Overruled.
Go ahead.
I forgot what I already mentioned. It'd have to probably be decomposing in an anaerobic type of environment. The temperature would have to be correct, the pH would have to be correct, and it'd have to be loaded with certain types of bacteria. These bacteria are normally found within the human body.
So you would have to have a couple of pounds of hamburger wrapped up in a bag and somehow sealed, left in the trunk of a car to rot, and it would have to have bacteria normally found in the human body in it. Do I have that right?
If the hamburger meat was raw and it had a very high fat content, that probably may cause it, yes.
So we're not talking about somebody eating a hamburger and then bleeding.
Overruled.
Could it be caused by somebody eating a hamburger and wiping their face?
No.
Did you see any evidence in what you've seen of any pieces of hamburger on anything you looked at?
No.
The counsel asked you about the Staphylopoulos study. I think that's how it's pronounced, Staphylopoulos. Did he find, and again, you said his study was of was a one-time examination of a body or two. Is that correct?
I believe it was two bodies.
Two bodies.
They were floating in the Mediterranean Sea or some such thing.
Okay. People who were floating in the water, picked up, and then they looked, but they only looked one time, not over 4 years like you did.
Correct.
Now, did the compounds that he found, were they among the 478 that you had found, or did he found additional ones? Or do you recall?
I don't recall. I know there was quite a bit of overlap, but I can't recall. He had 80 compounds. I just don't recall that. But I remember there was significant overlap.
The positive control you used, again, describe for the jury what that was, how you got it, why you got it, and what you did with it.
Since we had never studied a child or a person or a human decomposing in the trunk of a car before, we looked around for a positive control, a control being a person that's decomposing in the trunk of a car. Obviously, an adult may not have been a very good comparison. It's unfortunate, but we were able to find another such case in Montana where a child, approximately 3 years of age, had died and was wrapped in a blanket and left in the trunk of the car for 3 months. Granted, the time frame was much longer than what we saw here, but the point of that positive control was to confirm that compounds such as we saw in the Florida trunk that were consistent with human decomposition could be formed in that type of an environment.
And how did the test on the carpet in this case compare to the positive control sample from the Montana case?
If you look at those 5 compounds, 4 of those were present.
And the only one that wasn't was chloroform.
Correct.
And that was the substance that was in such large abundance in your study. Is that correct?
Mr. Stain, that's the last question.
Is chloroform the substance you talked about earlier in your testimony?
Correct.
Now, the absence of fluorinated compounds, did you test the Montana carpet, the Montana blanket, where a 3-year-old had decomposed for those compounds?
We didn't test specifically for them, but if they had been present, we would have been able to identify them.
And were they present?
No, they were not.
And do you have an opinion as to why those fluorinated compounds would not be present in that control case and in the case here?
Objection, Judge. Calls for speculation.
Overruled.
Go ahead.
Adults that we've studied over the years produce a number of fluorinated compounds. These are compounds that have fluorine in them. It is assumed that the fluorine is...
To the witness assuming things, and it calls for speculation, and we move to strike.
Overruled.
Go ahead, sir.
It is assumed that these fluorinated compounds accumulate in the human body by a process called bioaccumulation. It's like if you eat lead paint chips. You know, you eat one little piece of paint chip that has lead in it, you get a little bit of lead in your body, but you start eating a whole bunch of paint chips and you get a whole bunch of lead. And that may not be a great example, but nevertheless. So over time, what you do is if you drink fluorinated water over your lifetime, and a lot of water in the United States has been fluorinated, you will bioaccumulate fluorine in your bone and tissue. When you die and decompose, these bacteria and microbes convert those fluorinated material, the fluorine material, into fluorinated compounds. Now, if you go to countries that do not fluorinate their water, like Brussels, for instance, the people you see in those type of environments that have not spent a lifetime ingesting fluorinated compounds, you don't see these fluorinated compounds in the water. Now, in the body, in the decomposing odor. Now, in a small child, it is assumed that the child, maybe they drink water, but enough time has not passed to ingest enough fluorine to begin bioaccumulating it to the level that the instrument can detect. And that seems to hold true for both the positive control from Montana as well as the samples from the Florida trunk.
And that coincides with the studies of adults in countries that don't fluorinate their water, and you don't find that in the odor. Is that what you said?
Overruled.
Correct.
No further questions.
Dr. Voss, you actually addressed this issue with the fluoride in your report, did you not?
I believe I did, yes.
And you have made it clear that this has not been studied.
Not in children, no.
That the fact that there was not any fluoride there has not been studied at all.
Not in children, no.
But you're willing to come to this jury under oath and testify that the reason you didn't find fluoride was because she's a child and didn't have enough time to drink enough water.
Objection argumentative of what he's willing.
Overruled. He can answer the question if he can.
Can you please repeat it one more time? I'm sorry.
You're willing to come in front of this jury and give them information as an expert witness to facts that have not been studied at all.
Bioaccumulation is a well-known phenomenon in the animal kingdom, for instance, even in plants. Yes, it is my opinion that that is what has happened.
It's your opinion on something that has never been studied.
Well, fortunately, we don't get a lot of children.
My question, sir, is it's an opinion that's based on something that has never been studied.
It is an opinion based on something that has not been studied, but founded in a well-known phenomenon called bioaccumulation.
Now, you talked about and you testified to this jury about the stain, the paper towels.
Yes.
Now, these paper towels were found in the trash bag,
I believe that's what I was told, yes.
and you have no evidence, because, well, let me rephrase that. Sir, you have no information that paper towel and that stain have anything to do with one another.
I don't know if that's actually completely true. I mean, the reason we even did that is because Dr. Haskell, an entomologist, identified...
Sir, do not testify about another individual.
Objection, Mr. Baez.
Yes, sir. He was about.
You asked him a question, you get the answer. Go ahead.
I forget what it was, but Dr. Neil Haskell sent me those paper towels. On those paper towels, he identified fly pupil casings. He was curious as to
Judge,
why...
I'm going to object to this commentary specifically way outside of. Yes, I'll withdraw the question.
Okay, thank you.
You have no idea and no firsthand knowledge that those paper towels have anything to do with that stain, do you, sir?
Objection, compound question. One is an idea, the other is first-hand.
I'll rephrase. You
Sustained.
have no firsthand knowledge that those paper towels have anything to do with that stain, do you, sir?
I do not know.
But that's still something you're willing to tell this jury.
If it's found in conjunction as evidence in the trunk of the car, I don't see why it's not relevant.
And you have no idea as to the chemical, as to what would have to occur for these acids, these fatty acids that could be found in meat, and how they would end up on that paper towel.
Well, again, something attracted the flies to the paper towels. And
My question to you, sir, is you have no idea the circumstances of how, whether that was used to clean up any meat after cooking or anything like that, or to clean up a counter.
there was no meat residue on the paper towels we extracted.
But there were fatty acids that would be consistent with meat. Wouldn't that be correct, sir?
Consistent with the breakdown of adipose tissue.
Which is also found in meat.
Fat is found in meat.
Yes. Now, the marijuana, was that found outside?
Sustained.
Judge, I believe counsel
Sustained.
during cross-examination addressed these paper towels.
Sustained.
No further questions.
May the doctor be excused.
He may step down. There is an issue that we need to address
Okay, you may stand down, doctor.
outside the presence of the jury.
Okay. Jury, if you want to stand and take a stretch break, or do you need to go back in the room for a minute?
We may want to approach on scheduling.
You may proceed.
All right, Mr. Bloisey, you've testified already a few times here as a crime scene investigator. I want to draw your attention to a specific item of evidence. Did you receive a trash or garbage bag from a fellow employee by the name of Awilda McBride?
Yes.
Do you recall, or do the records of the Orange County Sheriff reflect the date and time you received that item of evidence?
July 16, 2008, about 23:07 hours, which was 11:06 p.m.
Are you the individual that took possession from Ms. McBride?
Yes.
Okay. What is the first thing you do with this item of evidence?
What I did, I removed the plastic bag that was containing several trash items, and then I put it aside, and I did a visual inspection of the items.
All right. Did you also photograph the item as it was received and then as you began to open it?
Correct.
If I may have what has been marked as Z for identification. Investigator Bloise, can you see Z for identification displayed on the monitor in front of you?
That was the plastic bag, white with blue handlings that I received from Wildemar Bride.
Does that photograph fairly and accurately depict the condition of the item upon your receipt of it?
Yes.
Your Honor, at this point, I would seek to introduce Z for identification into evidence as the state's next numbered exhibit.
What says the defense?
No objection, sir.
To be received in evidence, the state's numbered.
Permission to publish this item to the jury.
You may publish.
Investigator Bloise, can you explain for the jury what we're looking at?
We're looking right now the paper bag that was inside the plastic bag with blue handles, and from this photograph, you don't see the items, but the items, they're inside, and there's a little wet in the area, and the paper bag, and some wet and plastic bag.
All right, let me see if I understand you correctly. The paper that is under the white bag, is that something that the white bag was inside of?
The paper bag was inside. When I received the trash, I received the plastic bag inside the paper bag, and then I opened it.
Okay. Now, the paper appears to have some sort of liquid on it?
Yes, some kind of liquid.
All right. Could you tell if the exterior of the plastic bag was wet, or was that liquid coming from the inside of the bag? Any way for you to have determined that?
My best recollection was a little wet.
Okay. Now, the handles on that bag, were they tied securely, or were they open? Was the mouth of the bag open at all?
They're open.
So once you photograph this item, what is the next thing that you do with it?
I start to inspect the interior of the plastic bag, the items.
Okay. Can you see AA for identification?
Yes,
I imagine the inspection of the items required removal from the white plastic bag?
correct.
Okay. Did you cut the bag in order to remove the items, or did you pull them out of the bag in some other way?
I pull out of the bag.
Does AA fairly and accurately reflect the condition of the items contained inside the white plastic bag after you received it?
Yes.
Your Honor, at this point, I would seek to introduce AA for identification into evidence.
What says the defense?
No objection, sir.
Received in evidence, the state's numbered.
Permission to publish the item.
You may publish.
Investigator Bloise, did you do anything else that evening with this bag?
I just did a visual inspection of the items, and then I proceed to put the items with the paper on inside the dry room.
Okay. Now, what is the dry room?
The dry room is the rooms that we have in the forensic garage to place items that are wet in order to get it dry, so we can have a special rooms in order to do that.
All right. Were these items inside the bag wet?
Some items, yes. Mhm.
Okay. Did this item, or did these items have any particular odor that you would be able to describe?
Smell of trash, normal trash.
Right. Did it smell to you the same as the car?
No.
How long were the items in the dry room?
I removed the items and put into the dry room. May I refer to my notes,
Will that assist you in refreshing your recollection?
please?
With the court's permission, may he refer to his notes?
You may.
Thank you, Your Honor. I collected on 16, 2008, what I'm saying before, 11:07 hours. And then the 18th of July, I removed the items from the dry room, and I placed it in the box. And then I put the dry room, I put the items, the trash, in the evidence locker. So most likely from the 17, 18, 2 days, and then from the 18 to the 18, I removed from the dry room to my evidence locker. So 2 days.
Okay. I imagine then, that once you removed them from the dry room and placed them into an evidence locker, they were dry?
Yes.
If I may show you what's been marked as A-B for identification, can you see that?
Yes.
Was that photograph taken the night that you received the items?
Correct.
And what is it intended to depict?
Basically, it's a close-up of some of the trash items, the napkins, some Velveeta package, and all the items among the trash area.
All right. Does this photograph fairly and accurately depict the condition, at least of this section of the garbage, on the evening that you received the item?
Yes.
Your Honor, at this point, I would seek to introduce A-B for identification into evidence.
No objections.
We received an evidence that states numbered.
129.
Permission to publish?
You may publish.
All right. Investigator Bloise, you had mentioned specific items in here. What is this item?
The napkin.
If I may have AC for identification? Investigator, can you see AC for identification?
Yes.
And what is it that you are intending to depict through the use of photography here?
It's the napkins that I collected from the trash, and I placed it in the plastic bag.
Okay. Do you recall, or do the records of the Orange County Sheriff reflect the date that you collected those napkins and placed them into that plastic bag?
That was previous to my inspection.
I'm sorry?
That was when I inspected the trash.
Does that photograph fairly and accurately depict the condition of those items shortly after your receipt of them?
Yes.
Your Honor, at this point, I would seek to introduce AC for identification into evidence.
What says the defense?
No objection, sir.
Received in evidence as states numbered.
130.
Permission to publish that item to the
You
jury.
may publish.
Investigator Bloise, were these the same type of item, all napkins or paper towels?
That's the same.
Did you eventually place all of the items out on a table in the forensic section and photograph them?
Correct.
If I may have AD for identification. Do you see AD?
No, now, yes. Yes, it's the napkins, aluminum foil, hanger, empty box of cigarette, and dry sheet, and one portion of the detergent, a bottle, and a hammer.
All right. Does that photograph fairly and accurately depict part of your inventory of the items in the garbage bag once they were dried and placed out for the purpose of photography?
Yes.
All right. Your Honor, at this point, I would seek to introduce AD for identification into evidence.
What says the defense?
No objections.
Be received in evidence as states numbered.
131.
May this item be published.
May publish.
All right. In this photograph, you've gathered, the predominant image in the photograph is your gathering of all of the paper-type products that were inside the garbage in one area.
Yes.
If I may have AE for identification. Do you see AE?
Not yet.
Okay.
Now, yes.
All right. Does that photograph fairly and accurately depict items that you inventoried from the garbage?
Yes.
Your Honor, at this point, I would seek to introduce AE for identification into evidence.
No objections.
Be received in evidence as states numbered.
132.
Permission to publish this item.
You may publish.
Okay. What items are we seeing here?
Several dry sheet, papers, aluminum foil, bottle of Crystal Light, can of Coca-Cola, bottle of detergent, and a hammer, among other items.
If I may have AF for identification. Does AF, once it comes up, fairly and accurately depict the contents of the white plastic trash bag?
Yes.
Your Honor, at this point, I would seek to introduce AF for identification into evidence.
What says the defense?
No objections.
Be received in evidence as states numbered.
133.
Permission to publish.
You may publish.
Is this the entire contents of that plastic bag?
Correct.
If I may have AG for identification. Do you see AG?
Yes.
All right. Is that a receipt from Fusion Ultra Lounge?
Correct.
Was this inside the garbage?
Yes.
Does this photograph fairly and accurately depict the condition of that receipt?
Yes.
Your Honor, at this point, I would seek to introduce AG for identification into evidence.
What says the defense?
We would object. Relevance and 403.
Objection overruled. Be received in evidence as states numbered.
Permission to publish the item?
You may publish.
And AH for identification, please. Do you see AH?
Yes.
Is that is that documentation from Full Sail University?
Correct.
Was that inside the garbage?
Yes.
Does that photograph fairly and accurately depict the condition of that item when you retrieved it from the garbage for photography?
Yes.
Your Honor, at this point, I would seek to introduce AH for identification into evidence.
What says the defense?
No objections.
Be received in evidence as states numbered.
Permission to publish that, Your Honor.
You may publish.
If I may approach the witness.
Okay.
I'm going to show you what's been marked as HO for identification. Have you taken a look at the exterior of that packaging and tell me if you recognize it as something you've had contact with in the past?
Yes, this is the box that I prepared to put all the trash items, and is a tag number identification H51976. And then I did a description, a trash bag with the blue handle with several items in it.
I may show you what's been marked as HP for identification. Have you taken a look at this packaging? And that one's already open, the contents inside, and tell me if you recognize that as something you've had contact with in the past.
Yes,
How do you recognize it?
had my initial on it, and its tag number, identification number is H51976. I was a napkins from the trash that I collected.
When you collected those items, did you place them in this box and seal it?
Yes.
Your Honor, at this point, I would seek to, well, HP, which is 126, is already in evidence. I believe that was conditionally admitted upon this witness's testimony. And I would also seek to introduce HO for identification into evidence.
Okay, HP, which was 126, which was conditionally admitted. The state is now offering it into evidence with no conditions.
We would still object as the other individual who gave it to the witness that it was introduced by has still not been testified as to its chain of custody.
Okay, then I will wait until the other individual testifies. What was the other exhibit you had offered now? What says the defense as the HO?
No objections on that, Judge.
As the HO, that will be received in evidence as states numbered.
Your Honor, on a previous occasion, when he testified, he identified NN for identification, and I would seek to introduce that into evidence this time. What
says the defense? It'll be received in evidence as states numbered
137.
Investigator Bloisy, did you do a written inventory of all of the items in the white trash bag?
Yes, I did.
Right. Do you have that available to you?
Yes, in my report.
If I could refer you to page 23 of your report. Were there 37 items in the bag?
That is correct, 37.
Okay. And in that box, did you place each of the 37 items into separate envelopes?
Correct.
Okay. Can you detail for the members of the jury each of those items?
Yes. The first one is an empty Coca-Cola cherry can, cherry Coca-Cola can, 12 ounces, and with number 2145. Second one was empty Coca-Cola classic can, 12 ounces, with number 22502. Empty Milwaukee Best Light beer can, empty Milwaukee Best Light beer can, with number C7019E. The other one is empty Sprite can, 12 ounces, with number 16090RA. The next one will be empty circular metal box Copenhagen tobacco with number SLN8178. 1 hairpin, 3 plastic tie wraps, empty Dr. Pepper 12 ounces, proof of purchase number is 2239E505168X. The other one is empty Pepsi can, 12 ounces, proof of purchase number 1608RF01238. The next one is a Mountain Dew, 12 ounces, proof of purchases 2122E50448X. The other one is Oscar Mayer plastic container, proof of purchasing 447001090. We're going for the item number 12. Empty small crystal light container number is 2494554. Empty crystal light bottle 60 ounces with brown liquid inside, proof of purchasing 430093911. Bottle of Kiwi Sport Cleaner, 5.5 ounces, proof of purchases 31600247001. Empty bottle of Arm Hammer, 80 ounces, proof of purchasing 3320000904330. Crystal Light soft drink mix with number 43000950033. Empty black container anchor, empty unbroken pizza box, pizza a symbol of quality, that was the name. Pizza symbol of quality. The next one is empty carton of cherry Coke, 12 packages, proof of purchasing 49003103. The next one was a Belvita, 10.3 ounces, with napkin attached on it, with expiration date 11 February 2009. Another one is a carton of Belvita, 12 ounces, proof of purchases 21000658393. Belvita again, 4 ounces, proof of purchases 210065643. Package of Parliament Lights, which is a cigarette, empty package. Purchase number is 28200190008. Empty pack of Marlboro with number 233022. Empty pack of Trident Splash Proof of Purchase 12546671123. 2 empty aluminum wraps of Velveeta cheese sauce. Roma with napkin attached to it. Documents of full sale orientation and registration. 3 receipts. Document dated on May 9, 2008. 4 air freshener sheets. 5 napkins. Plastic wrap with sulfur garlic chicken of proof of purchases 138004514. 3 small pieces of plastic wrap, and then 3 pieces of aluminum foil. Total items, 37.
All right, I believe you missed item number 9 and item number 27. What are those?
Number 9?
Yes, sir.
Yes, Sprite, canned soda, 12 ounces, proof of purchase 16090RA, and number 7?
27.
Oh, 27, sorry. Piece of fabric that say LLGG made in Honduras of USA fabric.
All of the aluminum drink cans that you mentioned, were they all empty?
Yes,
You had mentioned a bottle of Arm & Hammer laundry detergent. Was that empty?
yes,
You mentioned the bottle of Crystal Light soft drink mix. Was that empty?
yes,
The pizza box, anything inside?
no,
The items that you identified as Velveeta, cartons of Velveeta, empty?
yes,
The item that you identified as the aluminum foil from the Velveeta cheese sauce, empty?
yes,
The plastic wrapper with the Stouffer's garlic chicken, empty?
yes,
And you talked about 4 air freshener sheets. Are these dryer sheets like the ones that you had testified earlier were in the vehicle?
correct.
Thank you. I have no other questions of the witness, Your Honor.
Cross-examination.
May it please the court. Ms. Drain. Good morning, ladies and gentlemen. Good morning, Mr. Bloise.
Good morning, Counselor.
The trash that you had originally collected, you testified that it was wet,
Correct,
and then you put it in a dry room.
correct.
Then it was dry.
The items that I collected,
Yes.
some of the items, they're wet and some they're dry.
My question to you, sir, is after you took them out of the dry room, they were dry.
Correct, I'm sorry, yes.
And I guess the purpose of that is to dry them and get rid of the liquid.
Correct, yeah.
And I'm going to show you Defense Exhibit C, which includes both photographs that have been admitted into evidence.
Yes.
Can we at least identify for the record which photographs they are, Your Honor?
Show you a side-by-side photograph of states evidence 133 and 128. Can you see that, sir?
Yes,
Your Honor, may I publish to the jury as well?
Yes?
Now, these two photographs look completely different, do they not, sir?
yes,
And that's as a result of what was done in the dry room.
correct.
Now, when you testified about your inventory list and all of the things that were empty, you were testifying to an inventory that you did subsequent to them coming out of the driver.
That is correct.
Now, you had no idea that this would be critical evidence later on in the case, did you?
When I initially received it, I just received like evidence.
And you had no idea that later on, this trash would become a disputed item in this case.
Correct.
So it was not your intention to intentionally destroy any type of evidence, was it, sir?
No.
But ultimately, that's kind of what happened, correct?
I'm going to object. There's no destruction of evidence. He testified to the procedure he used. When he received it, he dried it, and then he...
Speaking objections, Judge.
Objection sustained.
Sir, you had no idea that the evidence would be altered, correct?
When I received the items, in this case, the trash, I just received like a trash, and then I proceed to preserve it.
To preserve it in a dry form.
Yes, 2 days.
And you had no idea that it would alter significant evidence in this case.
Objection asked and answered.
Overruled.
When I received the items, I just preserve it as the protocols that we have, and then I don't consider myself that I destroy any kind of evidence because the evidence is there. I preserve it, I document it through photograph, and then I put it in the dry room, and then I preserve it in a box. Normal procedure.
Investigator Bloise, no one's accusing you of destroying evidence. My question to you is, you had no idea that you would be altering evidence that might become important to this jury.
Your Honor, I'm going to object. There's no evidence that there was any alteration.
Now, can we have AC? You have, was it you that packaged, I'm showing you now a photograph of AC. Defense, state's evidence. State's evidence 130. May I publish that to the jury?
You may.
A little. Thank you, Judge. Can everyone see that? Not yet. Okay. Now, these are paper towels that were collected from the trash,
Yes,
and they were at one time moist,
yes,
and then they were placed in the dry room,
yes.
and then they were dry,
When I placed it in the dry room, yes, dry.
and then you put them in a plastic bag.
Yes,
Now, Investigator Bloise, it's your understanding and your knowledge that should items be needed to be tested for DNA, that you should not package them in plastic bags, correct?
that is correct, but that specific item don't have any, at this time, I don't have any values for DNA at that time.
At that time, but you don't know if at a later time this would be important for testing for DNA if someone came up with some accusation that this was more than just trash.
Your Honor, I'm going to object. He's asking him to speculate.
Sustained as to that question.
You anticipated this being important enough evidence to separate, correct?
Correct.
And this was important enough for you to put in a plastic bag, correct?
I just put it in the plastic bag.
And you do not know if later on it would be important to have it tested for DNA.
At that time that I placed and secured in the plastic bag, I inspected the napkins very well. I don't see any forensic values related with DNA, such blood, or any kind of indication of body fluid. Just I observed was wet, and there's no indication that was any kind of forensic values to tested for DNA.
And you know that DNA just doesn't test blood, correct?
Correct.
You can test saliva.
Saliva, it's very difficult to determine by the lab, I guess.
The
DNA.
cell breakdown, that would be.
There's no evidence that this is within the witness's expertise.
I'd object to the speaking objections, Judge.
Next question.
Semen, you can get DNA from semen?
Yes, but
Anything with a cell breakdown, correct?
my best to my knowledge, yes.
Okay. So we can unpublish, Judge. And, sir, it was not your intention to destroy or alter any evidence when packaging this piece of evidence, correct?
Objection to the form of the question.
Pardon, I didn't hear you, Ms.
Sorry, I said objection to the form of the question. There's assumes facts, not in evidence.
Sustained.
It's not your intention to alter the evidence in any way, was it, sir?
Your Honor, same objection. It was the same question.
Sustained. He's been asked that question a couple of times, and he's already answered it. Redirect.
Thank you. Investigator Boise, why is it that you need to dry these items before they are stored?
The purpose to let it dry is because when we inspect the evidence that is dry, it's a part of protocol to let it dry in order to re-inspect it again, because it's a better condition to inspect the items. When the items is very dry, like for instance, example, blood on clothing, we let it dry because it's more secure for us, and at the same time, it's in good condition, better condition to be examined, that piece of evidence.
All right. If an item is wet, is there a concern that it will become moldy?
Correct.
Does your protocol require that items be packaged in a form that, where they could breathe, in paper?
Correct.
The carpet that you had discussed removing from the car during your earlier testimony, was that also dry?
Yes.
The item that you did place in plastic, was that done because there was evidence of bug larvae on that item?
I don't remember right now that specific.
Okay. That's all I have, Your Honor. Thank you.
Recross on those issues?
You mentioned that as part of your protocol, that you dry evidence, correct?
Correct.
And you later are aware that air samples were taken of the dry garbage.
My best I don't have any recollection regarding that question, Counselor.
Okay, so you have no idea whether air samples were taken of the dry garbage?
Objection asked and answered.
No. You're talking about the
Overall.
trash, Counselor? No.
Now, sir, Ms. Drain-Burdick mentioned that there was insect larvae on the napkins or in the trash, correct?
What I answer is I don't have any recollection about that.
Okay. But you're aware that you can collect DNA samples from insect larvae, aren't you? Are you not, sir?
This is not part of my expertise.
Just a second. Your objection?
Objection. This is outside of the witness.
Sustain.
Sir, you know that you can collect DNA from any cell in the body with the exception of red blood cells, do you not?
Same objection.
Sustain beyond the scope of the redirect.
Thank you, Judge. No further.
Okay. Will the witness be excused?
Yes, you may.
Thank you, sir.
Thank you, Your Honor.
Excused.
Thank you.
State may call in next witness.
State would recall Dr. Arpad Voss briefly.
Arpad Vass, Arpad Vass.
Good morning, Doctor.
Hello.
I apologize for bringing you back here again. I need to correct a mistake of mine from yesterday. I want to show you State's Exhibit IR for identification. And ask if you recognize that as the can you were sent as opposed to the one I showed you yesterday, which was IO.
Yes.
Okay, you recognize that that's the correct one you were sent?
I believe so, yes.
Okay, what do you, based on what?
These initials.
Okay, you see your initial on?
It's hard to see with all the tape. And the problem is,
You can remove part of it.
Excuse me, Keith.
Oh, I'm sorry, I said you can remove part of it. Do you see your initials on there?
yes.
Okay, very good.
Okay.
And this is the one, the can that you tested that we talked about yesterday as opposed to the one I showed you.
That's correct.
This time, Your Honor, I would have to correct my error and substitute.
Judge, I want to object to counsel's commentary.
Objection overruled.
Substitute State's Exhibit IR as State's Exhibit 114 in evidence as opposed to IO, which is.
What says the defense?
We just renew all previous motions and objections.
Noted previous objections. Objections will be overruled and be entered in evidence as states numbered.
And IO would return to, in evidence, identification as IO.
Right.
Thank you, sir. No other questions.
Please, the court.
Cross-examination.
Yes, sir. Dr. Voss, yesterday you testified about a piece of evidence that you did not examine.
I looked at the can. The can is not what I examined for evidence.
And you told this jury that there were identifications on that can.
Objection. That is not in evidence. If we can explain more at the bench.
Dr. Voss?
You may proceed.
Dr. Voss, yesterday you mistakenly admitted the wrong piece of evidence in this case.
Apparently, yes.
And this was after reading the label on the can that you were handed to by Mr. Ashton.
Yes.
And perhaps one of the reasons why you are not that familiar with the chain of custody of evidence is because you're from a research lab, not a forensic lab.
Objection scope.
Sustain as to that last question.
You're not accustomed to handling evidence, are you, sir?
Objection scope.
I'll let him answer that question overruled.
No, we're not a forensic lab, so we don't handle evidence all that frequently, no.
And the sensitivity that comes along with ensuring that juries get the right information.
Scope.
Sustain.
I have no further questions. Thank you, sir.